to SIAC China webinar. Today's topic is from Commencement of Arbitration to the Constitution of the Arbitral Tribunal, a practical guide to SIAC arbitration. I am Zhang Chunyuan, the Chief Representative China of SIAC. So please allow me to introduce the moderator and panelists today. Mr. Zhang Chung, partner of the Freshfields Hong Kong office. Mr. Kelvin Ko, partner of the TSMP Law Corporation, Singapore office. Ms. Ng Hui Min, partner of the Dentons, Singapore office. And Ms. Vicky Zhao, partner of the MJ Law Firm, Beijing office. And of course, our moderator today is Ms. Qian Wu, counsel of SIAC. So welcome the moderator and the panelists. So Qian, please.
Thank you, Chunyuan, for the introduction. First of all, we want to thank our four panelists accepting our invitation to speak in our China chapter today. Well, the goal of today's webinar is to provide practical guidance on commencing arbitration and filing the procedural applications, as well as the some procedural tools such as early dismissal. So first of all, we would like to invite Ms. Ong from Dentons to address the issue on how to file notice of arbitration effectively. Ms. Ong, please.
Thank you, Ms. Qian, for the introduction, and I would like to thank SIAC for the invitation for me to share on the topic of the practical and strategic considerations in the filing of a notice of arbitration today. And just please allow me to briefly share my slides for this topic. Okay, so here we go. The topic that I'll be speaking on today is on the strategic and practical considerations in the filing of the notice of arbitration. I'm sure many of you may have experience, in the filing of the notice of arbitration, but there are certain things that are not often emphasized. So these are some of the things that I would like to share with you today. We'll be going through some of the things like, for example, what are the steps to consider before the filing of the notice of arbitration, followed by the contents as well as the timing of filing of the notice, and in supporting documents, excuse me, to be included in the notice of arbitration, and lastly, whether or not to include the statement of claim in the notice of arbitration. Steps before the filing of the notice of arbitration. Some of the things to bear in mind before commencing the arbitration is to consider whether or not there are any pre-arbitration procedures which have to be satisfied before the arbitration could be commenced. These are some of the important things which have to be considered, especially when you want to ensure that the arbitration award at the end of the day is an enforceable one. So for example, arbitration agreements may certain times contain clauses relating to the steps, like for example, mandatory negotiations as well as and/or going for mediation. So parties are required to observe such requirements closely and to ensure that these steps are followed. So I'm setting out here an example of a multi-tiered dispute resolution clause. So these are the clauses which can oftentimes find themselves in arbitration agreements. For example, where a dispute has arisen between parties, the party that thinks that there's a dispute may give notice to the other party of the fact that there's a dispute that has arisen, and parties shall attempt in good faith to resolve the dispute. And if the dispute cannot be resolved within a stipulated time frame, in the agreement, in the example I've given here is 30 days, then parties agree to enter into mediation. So there are two steps here. One is to actually negotiate, and followed by mediation. And only if both negotiations and mediations have failed, then the dispute is referred to arbitration. So before the filing of the notice of arbitration, one must consider whether or not there are such requirements to fulfill. The next thing, in the event that the negotiations requirements are not fulfilled, then there may be an issue that the other party may raise this jurisdictional challenge to the arbitration. And if the tribunal is found not to have any jurisdiction, then the award made by the tribunal may be set aside. The next topic that I would like to go through is on the contents and the time of filing of the notice of arbitration. The particulars of the notice are set out in SIAC Rules, Rule 3.18K. I would just like to emphasize and highlight here that in arbitration agreements, sometimes the specific SIAC rules are actually referred to, and it may not necessarily be the latest version of the SIAC rules. There are examples of such agreements they may refer to an earlier version, or if the agreement refers to the SIAC rules as subsisting from time to time, then you can take it that we are referring to the latest version of the SIAC rules. So if the agreement refers to an earlier version, then the requirements to fulfill will be those set out in the earlier version of the SIAC rules. The date of commencement of the arbitration will be the date of receipt of the notice of arbitration by the SIAC registrar. And one thing very important to take note in the filing of the notice of arbitration is to ensure that the issue of limitation is taken care of. So for example, if you are aware that a certain course of action may be time-barred shortly, then there is impetus to file the notice of arbitration as soon as possible. Not only is the timing important, the course of action that is being set out in the notice of arbitration is equally important, because the idea is to ensure that the relevant course of action is informed to the respondent in the notice of arbitration, so that the claimant's rights in filing the application, or rather the course of action before the limitation period ends, is safeguarded. So both the Arbitration Act as well as the International Arbitration Act have both made clear that the limitation period, the Limitation Act actually applies. So this is regardless of the fact that even though the SIAC rules says that the notice of arbitration only needs to set out a brief statement describing the nature and circumstances of the dispute. If a claimant is aware that he may have other causes of action which may be time-barred soon, then the claimant should err on the side of caution and set out in greater detail the relevant elements satisfying the various causes of action, so as to give the respondent notice of the cause of action and to prevent an issue that the cause of action may be time-barred because of the fact that not sufficient information is set out in the notice of arbitration. So when in doubt, always adopt a substance over form approach in setting out information in the notice of arbitration. The issue of the filing of the timing of the filing of the notice of arbitration could also affect the calculation of interest on damages. Sometimes when parties are still talking to each other, barring circumstances where there is a multi-tiered clause. So maybe there is no multi-tiered dispute resolution clause, but claimant and respondent are still talking to each other to see whether or not they can possibly resolve the matter amicably. Under such circumstances, the claimant may consider whether or not it wants to proceed to file the application, the notice of arbitration earlier, so that in the event that it is successful later on, it can claim interest for a longer period of time. Under the arbitration rules, the tribunal is entitled to, empowered to award interest for any period of time. And an example is usually from the date that the notice of arbitration is filed. The next topic that I'll be speaking about is on the supporting documents. The documents which are required to be submitted along with the notice of arbitration are basically the arbitration agreement as well as the contract out of which the dispute arose. The other supporting documents can be included in the statement of claim. So ordinarily, we do not suggest for the claimant to put in more documents than necessary. And the reason for that is because there is always the opportunity of putting it in later on together with the statement of claim, and you do not wish to give the respondent more time to consider how to respond to the evidence. However, in some circumstances, if you're of the view that putting in more documents at the start may pressure the respondent into considering the weaknesses of his case, then one can consider putting in more supporting documents in the notice of arbitration. Okay, the last topic that I'll be sharing on is whether or not to even put in the statement of claim together with the notice of arbitration. This is not a requirement in the SIAC rules, although a claimant can certainly do so. And once the statement of claim is filed together with the notice of arbitration, this may shorten the time for the respondent to put in the statement of defense as well. So before the claimant does that, some of the issues that the claimant should consider is whether or not it even have sufficient documents and information in order to prepare the statement of claim. So unless the claimant is very certain that it has all that it needs, our suggestion is generally just to put in the notice of arbitration without the statement of claim. Because otherwise, if the claimant needs to amend the statement of claim later on, there will be further and possible cost consequences. And of course, if the claimant is seeking for the matter to be referred to expedited procedure, then the claimant may want to hold back the statement of claim first and see whether or not its request for the matter to be referred to expedited procedure, as set out in the notice of arbitration, is allowed. And if so, then it can consider what and how to plead its statement of claim later on. Okay, so with that, I've actually completed my presentation. So if you have any questions, please feel free to let me know.
Thank you very much, Hui Ming. I mean, I personally do have a question, but I see that the time is running, so I will reserve my question in the Q&A session. Meanwhile, if the audience has any questions, please let us know. In our Q&A session, we will invite the panelists to address your queries. So next, we have Mr. Kelvin Cole talking about the application for emergency arbitrator proceedings. I know we have quite a number of sessions for emergency arbitrator proceeding, but today we would like to hear more practical tips from Mr. Cole. Mr. Cole, please.
Thank you, Chen. Again, I guess with the proliferation of arbitration, one of the questions that's often raised. Sorry, could I get the slides on? Sorry, just realized that was not on. Thank you. Yes, so now with the proliferation of arbitration, we can see there are a lot of, I guess, interest in trying to seek interim relief. And I guess it's a relatively new trend, not exactly that new, but relatively new compared to other developments in arbitration for emergency relief to be sought. And in that regard, I think the SIAC has very clear rules setting up support for that. So perhaps before I go into the practical aspects, I would just like to cover some of the basic rules set out in the SIAC provisions. If I could move to the next slide. So really the key provisions relating to emergency relief falls under section Rule 30.2 and Rule 30.3. So 30.2 confirms that parties are able to actually then apply for such relief. And there are actually procedures set up in Schedule 1, which also covers how the emergency arbitrator may actually be appointed. And for Rule 30.3, that is where it clarifies the interplay between the courts as well as the tribunal. And it makes it clear that it's still possible to apply for interim relief from the courts, but only in certain circumstances. And again, this will actually be an important consideration as to whether when one needs to seek interim relief, they should actually seek one through the emergency interim relief procedure or to go to the relevant courts that really governs the law of the seat of the arbitration. Can I move to the next slide? So there are a few parts of Schedule 1. Again, I think the rules set it out quite clearly but just a few points that I will highlight here. The first is that the application needs to set out the nature of relief sought, reasons why a party is entitled to such relief, and a statement certifying that the parties have been provided with a copy of the applications or steps taken in good faith to provide such notice. Well, this is actually quite important at this juncture because, again, when we look at the issue of why a party is entitled to such relief, again, this is not the substantive submissions that can be dealt with later in the submissions once the emergency arbitrator has been appointed. And bear in mind, most of these applications are actually done at short notice, so they may not actually contain the full details of all the information of the claim. But it is important to bear in mind what's the extent of disclosure that we want to make in such an application, given that this will also give notice to the other party, and there may be strategic considerations as to what is the degree of disclosure that we're going to make at this juncture. Now, in order to ensure that the procedure moves very quickly, the rules specifically provide that the president of the SIAC will seek to appoint an emergency arbitrator within 1 day. And after the communication of appointment, it is possible to challenge the appointment of emergency arbitrator within 2 days. And in most of the cases, well, the interim order or award is to be made within 14 days from the date of appointment, unless the registrar extends time in exceptional cases. And finally, it's important to note that the interim relief ceases to be binding if the tribunal is not constituted within 90 days of relief, or when the tribunal makes a final award or the claim is withdrawn. So all of this actually have a bearing because in a sense, it is important to understand what is the avenues open when an application is made. For instance, you are actually entitled to challenge the appointment. So that actually potentially shortens the time that the emergency arbitrator has to consider the merits of the application. And in a convoluted matter, that may actually require an extension of time by the registrar. So using this, there's actually a potential for the respondents to actually buy additional time and to delay the entire proceedings. Now, let me just move on to the next slide. And these are some of the forms of interim relief that are often sought and granted. Again, I'm not going to go into details, but these are some of the forms that have actually been granted by the SIAC emergency arbitrators. Now, to move on to the next slide. Well, the important and I think one essential aspect is that the SIAC rules do not actually prescribe for criteria for granting interim relief. Well, the emergency arbitrator has broad discretion as it deems appropriate, and we have seen quite a number of different legal tests that have actually been considered and introduced in different cases, including the real probability of success, good arguable case. And of course, in many cases, we do also see the situations of balance of convenience coming into play. Again, because arbitration is really consensual in nature, this also provides actually an opportunity for parties at a time when they enter into the arbitration agreement to prescribe for certain standards that they think could be applicable for interim relief. So if that's something that is contemplated at the outset, that could actually affect the ease of seeking the reliefs, then parties may actually want to set out and agree on the lower standards so that when the tribunal actually has to consider the application, it will benefit from the clarity as agreed between the parties. Next slide, please. Now, if not, another reference we can see is the UNCITRAL model law, which actually prescribes for the relevant test, and it really falls on the issue of whether the harm will substantially outweigh the harm that's likely to result to the party against whom the measure is directed, and importantly, whether there's a reasonable possibility that the requesting party will succeed on the merits of the claim. Next slide, please. Now, the two most important considerations, again, when we're looking at interim relief, is that firstly, it's not possible to seek emergency interim relief on an ex parte basis. So that really means that you can't take the other party by surprise. So in situations where it's actually essential that we need some stealth and to prevent the other side from having advance notice and potentially risk the interim relief being negated, then again, we need to consider whether going to court directly may be a better option. And another point to consider is that you can't actually seek interim relief against third parties. This is a trite point in arbitration. But again, given that there are avenues for enforcement of interim orders, this may potentially be negated in some sense. So for instance, if you want to get a Mariva injunction and that you need to ensure that the banks abide by it, strictly speaking, you don't need to actually seek interim relief against the banks. But the fact that once you get the Mariva injunction, you get it enforced as a court order, that will have effect, and the banks will usually comply with such orders. Next slide, please. Now, again, when we talk about interim relief from court, again, I think it's quite clear Rule 30.3 allows court to grant interim relief. And again, I think one important consideration is whether the matter is urgent. Well, again, it always depends on the seat of the arbitration and depends on the jurisdiction. Well, from a Singapore perspective, I can say the courts have been quite open to try to grant such such interim orders to preserve evidence or assets, and have taken a very expensive reading of assets to include contractual rights, which if lost would not be remediable by an award of damages. So again, bear in mind I think the theory of minimal cure intervention. The Singapore court will only intervene if the tribunal has no power or is unable to act effectively. Next slide, please. Now, I think finally, the important consideration comes down to the issue of recognition and enforcement of emergency interim relief. Again, it really boils down why, when we look at the rules, how it's formulated, they say that the tribunal may, at the request of party, issue an order or award. Well, the issue of the order or award actually boils down to the definition of what an award is under each national legislation. Because the New York Convention in Uncitral Model Law has been silent as to this. And really, whether it is actually recognized depends on the laws of each jurisdictions. So for instance, in Singapore, it's very clear that the Arbitral Tribunal actually includes an emergency arbitrator right now, which means that interim relief can be enforced as a Singapore court order. But one problem is that the award does not actually include any interim relief granted by the tribunal. So one important thing when we're actually seeking an order in places where it's capable of being construed as both an award and an order is that, again, an order is potentially not susceptible to being set aside under the New York Convention. And what we have is a setting aside of the award. So that was actually a situation covered in Pukwafu Inda against Newmont. I see my time is running out. I think if I have chance later, I'll probably address on some of the intricacies of the interplay between the order and award. I think that's the end of the slide.
Thank you, Kelvin, very much. Thank you so much for sharing, this the rules and also how the Singapore courts deal with this kind of application, and also the comparison of interim measure you received from the emergency arbitrator and from that of the court. This is a very interesting topic, and I certainly have many questions. But at this time, I will let Ms. Vicky Zhao to address the multi-party and multi-contract issues now, and then when we're in the Q&A session, we can discuss more in details. Vicky, please. Vicky, you're on mute.
Thank you, Jen. So I have not prepared slides because I was assigned about 6 to 8 minutes. And when I look at the SIAC rules on joinder and consolidation, I find myself would not be able to even reading out the rules within that time frame. So I just give some thoughts and I think these are practical thoughts that I think which are important when the parties consider whether they would like to request for consolidation or joinder. So I will talk about 3 issues. Firstly, what is joinder and consolidation? And secondly, what is the basis for consolidation and joinder? And thirdly, what would be the effect on the constitution of the tribunal if there is a request for joinder or consolidation. So let me start with what is joinder and consolidation. So in simple words, to my understanding, when we talk about consolidate, we are talking about consolidate cases. We are talking about consolidate different arbitral proceedings into one proceeding. But when we talk about joinder, we are talking about to join additional party or parties into the existing arbitration proceeding. And I think a relevant concept would be intervention, which to my understanding is when an additional party, which is not a party to the existing arbitration proceeding, requests to be joined into the existing arbitration proceeding. So why they are important? So when I was working with SIAC around 2013 or 2014, we don't have consolidation or joinder rules in the SIAC arbitration rules. And I also didn't find it very important to have those rules, but nowadays I find it really important because, for example, we have more and more like financial innovative products. And I think a traditional view is that the financial institutions, they don't like arbitration because they have a bunch of contracts. And for example, for merger and acquisitions, you have term sheet, confidentiality agreement, share transfer agreements, and a lot of auxiliary contracts after that. So the parties find it important to have the possibility, at least, to join additional parties into the arbitration proceeding or to consolidate different arbitration proceedings together. So that is the scenario or the examples I see in nowadays that consolidation and joinder are really important to be existing in the arbitration rules. So secondly, I want to just briefly talk about my understanding as to what is the basis to join additional parties or to consolidate the arbitration proceedings. So as Kevin just mentioned, so the consent of the parties, I think that gives life to arbitration. So when we talk about consolidation and joinder, I think likewise, we have to find the consent among the parties and where this consent come from. So I think it's easy if all parties, including the additional party to be joined, as well as maybe tribunal arbitration institutions, everyone agrees with the joinder or consolidation, then we have no problem, just join. But I think the difficulty being, for example, firstly, the additional party, it objects to the joinder, or some of the parties, they don't agree with the consolidation. Then the question come up, who has the power to make the decision? And I think when I look at the SIAC rules, I also look at other institutional rules. So they all have different, sometimes, I think some of the arbitration institutions, they have very restrictive conditions and very high threshold to join a party or to consolidate arbitration proceedings. And some of the arbitration institutions, they are super flexible and they give the institution or the tribunal very broad discretion to join parties or to consolidate arbitration proceedings. And I think the risk is when we join parties or consolidate different arbitration proceedings, whether the final award can be enforced, or is there any reason, or whether this kind of joint or consolidation gives some party a reason to apply for setting aside the award at the end of the whole proceedings. So that is the risk, which means if the rules give broad or super feasibility to join or to consolidate, then the risk will be higher than other institutional rules. So in this sense, I think SIAC rules is at a very appropriate level in that sense, to my understanding, because when you look at joinder, the basis is firstly, I think it is 7.1, Article 7.1. So firstly, if it is based on the same arbitration agreement, and the additional party to be joined is prima facie bound by that same arbitration agreement. So if we are only look at one arbitration agreement, it keeps the things relatively simple. And secondly, if all parties, including the additional party, agree to the joinder, then okay, that is the safe part. So to me, I think this is prudent, and is I think it is a rule which gives the party who is not very familiar with this joinder things on a safer side. And also, if we look at consolidation, that is in 8.1. So I think this is relatively, compared to joinder, this gives more feasibility, because it is not only talking about all parties agree, which is the first part, and then if under the same arbitration agreement, that is the second scenario. And thirdly, so regarding consolidation, the SIAC arbitration rules also give the possibility of consolidation if these arbitration agreements are compatible. Also, if the disputes come from the same legal relationships, or the disputes arise from a principal contract plus ancillary contracts, or the dispute arise from same transaction or series transactions. So I think from a practical side, those should be the factors that the parties have to consider as to whether there is a consent among the different parties when you make the request for consolidation or joinder. And just very briefly on the third point regarding the appointment of arbitrators, I think the thing would be easy if the request is made before the appointment of any arbitrator, because then every party has the chance to participate in the constitution of the tribunal. However, if the tribunal is constituted already, then the risk being whether this procedure for example, nominating arbitrators to constitute the tribunal, whether there's any defects in this proceedings. So I think we have to be very careful about this, and we can talk about in much more detail later on. I think my time is running out, so I just stop there. Thank you, Jen.
Thank you, Vicky. I just want to add one thing on the feature of joinder and consolidation under the SIAC rules. This one thing I really like about it, because under the rules, if the SIAC Court of Arbitration has made a decision on the joinder application or the consolidation application at a later stage, when the tribunal is constituted, the tribunal can overturn the decision of the Court of Arbitration. So this is a really flexible approach that allows the tribunal to decide on the issue when the dispute is more crystallized. Anyway, thank you, Vicky. Now we're going to have John, who is going to address the very interesting question and one of the most frequent procedural issues in international arbitration, which is jurisdictional challenge. And we also request him to talk a bit about the early dismissal, which is another feature we introduced into our rules in 2016. Now, John, the floor is yours.
Sure, thank you very much, Qian, and a very good afternoon, good morning, good evening to everyone virtually. So I'm talking about two topics, jurisdictional objections primarily, and on a somewhat related topic of the early dismissal procedure. Now, jurisdictional objections. Like Vicky, I have taken a leaf from her book and I do not have slides. You will need to listen to me. But on jurisdictional objections is really much more of a conceptual topic. Now, it arises where a party says, for example, that there's no binding arbitration agreement between the parties, or that the disputes are outside the scope of the tribunal's jurisdiction. So how do you address that? If we look at the SIAC rules, objections to jurisdiction must be raised promptly and in general before you file a defense or within 14 days of the issue coming up. Now, in line with the model law, the tribunal has the power itself to rule on objections to jurisdiction, and the tribunal can make its ruling either as a preliminary question, meaning that it decides the question when it comes up, or it can reserve its decision until the final award. So the tribunal has those two choices, and in Singapore, the decision of the tribunal on jurisdiction can be challenged before the Singapore courts. Now, that's the theoretical position. How does it actually operate in practice? I think as an initial observation, I would say that if we compare the current situation to, say, 15, 20 years ago when I first started practicing arbitration, we are generally seeing fewer meritorious objections to jurisdiction. And that's simply a reflection of the fact that there are better drafted arbitration clauses these days. We certainly still come across them though, because disputes are becoming more complex, and in many ways the tactics that parties are adopting are actually becoming more aggressive. So let me move on to a couple of practical points in relation to dealing with jurisdictional objections. The first, a fairly obvious point, raise the objection as soon as possible before taking any positive step to affirm the jurisdiction of the tribunal or over the relevant issue. Now, as I said, this may at first blush seem obvious. And for example, if you're making a full challenge to jurisdiction, for example, the argument is that there was no agreement that was even signed, so I'm not bound by the arbitration agreement. If you're making a full challenge, I think it's pretty obvious that you will launch your objection very early in the proceedings. But less obvious, I think, are situations where you have a partial challenge. So for example, often you see over the course of an arbitration, there's scope creep. So the scope of a claim starts expanding, and up to a certain point, it starts going beyond the scope, really, of your arbitration agreement. And that is a situation where you are exceeding the tribunal's jurisdiction, arguably. And it's really in situations like that that sometimes you find a risk that parties don't raise the objections quickly enough. So again, it's really more of a situation where you're making a partial challenge. The challenge isn't really that obvious, and there is then a risk that the objection is raised at time. So that's the first practical point, raise your objection promptly. The second point is that the tribunal itself in SIAC arbitrations has primary jurisdiction to decide on jurisdiction. So that contrasts clearly with, for example, the PRC, where the position tends to be that the arbitral institution in the PRC will play a more involved role on jurisdiction questions. But in SIAC arbitrations, it is primarily the tribunal itself which has jurisdiction to decide. A third practical point, jurisdiction objections are often used as a tactical device. So for example, we've all come across cases where recalcitrant parties, typically respondents, for example, may not have a real defense. They may rely on the jurisdictional objection as a means to delay the proceedings in the hope that they can then extract a settlement from the counterparty. So jurisdictional objections are tactical in nature. Bring me on to a fourth point, which is that it's also an important tactical issue as to when the decision on the jurisdictional objection is made. So as I mentioned at the outset, jurisdictional objection decisions can be made either as a preliminary issue or question or in the final award. Now, which is better? It really depends on your situation. Now, if the decision is made as a preliminary question, that may be quite a good result if you are the party with a strong jurisdictional objection. Because if you believe you have a strong jurisdictional objection, it's decided as a preliminary question, you succeed, then you shut down the arbitration because the objection has succeeded. You either shut it down or at least part of the claim falls away. Similarly, if the strategy of the party making the objection is to delay the proceedings, then it might be good to have it heard as a preliminary question. Because if the tribunal deals with it as preliminary question, then there's a good chance that the rest of the arbitration proceeding is on hold while this question is being determined. Now, in contrast, there are situations where it is good for a jurisdictional objection to be dealt with in the final award itself. Now, that's good if you believe you have, for example, a good story on the facts. So you want the tribunal to actually hear your entire story before it decides the question of whether it has jurisdiction. Similarly, in some cases, parties want to string out the actual proceedings. They want to obtain more leverage before they settle the case, in which case it is sometimes good to make a jurisdictional objection and then string it out before the objection is actually decided upon. A fifth practical pointer is the tribunal's decision on jurisdiction, as I mentioned earlier, can be challenged before the Singapore courts. There are 2 points which flow from that. First, in Singapore, if you make a challenge to a tribunal's decision, so that means the tribunal decides on jurisdiction, one party disagrees with it, they bring that challenge to the Singapore courts. The Singapore courts, in fact, get to reconsider the substantive arguments on jurisdiction. So it's quite a broad jurisdiction on the part of the Singapore courts when dealing with jurisdictional challenges. And this importantly contrasts with the more limited grounds for reopening up the merits of an actual award in the context of a setting aside application. So the first takeaway point there is a broad ground for challenging jurisdictional decisions before the Singapore courts. And the second point, which is related, is that in Singapore, you can challenge a decision on jurisdiction both where it is a decision that the tribunal says they have jurisdiction and where they do not. That's not the case in many jurisdictions, but if the tribunal in the Singapore seated arbitration holds that they have no jurisdiction, you can still challenge that decision before the Singapore courts. And in fact, you get a bit of a second bite of the cherry. So that's a quick canter through jurisdictional decisions. A few quick words on the early dismissal procedure. Now, that procedure allows a party to have a claim or a defense dismissed on the basis that they are manifestly without legal merit or outside the jurisdiction of the tribunal. So in short, it's a bit of a summary judgment type procedure, but it's couched in terms of a dismissal. The tribunal obviously has jurisdiction to decide whether or not to hear the application there and then. And if the tribunal allows the early dismissal application to proceed, then ordinarily its decision must be rendered within 60 days of filing of the application. Two quick practical points there. The first, that the purpose of the early dismissal procedure, again, is to knock out only obviously unmeritorious claims. So those are claims which are manifestly without legal merit outside the jurisdiction of the tribunal. And the second point, it is easier to establish a legal objection as a basis for an early dismissal, whereas if the basis for the application is that there are complex factual disputes that underpin the early dismissal application, then there's much more of a question mark over whether a tribunal will deal with such an application in the context of early dismissal. And with that, let me hand the time back to Chien.
Thank you very much, John. Well, if I know that all the four panelists have completed their presentation on time, if I may have the privilege to ask one question, before I convey the audience question. So John, you just addressed the jurisdictional objection, and under the SIAC rules, we have Rule 28. Which is an objection on jurisdiction before the constitution of the tribunal. So basically, if the party thinks that the SIC has no competence, or the matter should not be conducted under the SIC rules, they can ask the registrar to refer the objection to the SIC Court of Arbitration, who is going to decide whether SIC has prima facie jurisdiction over the matter. As the threshold is very high, would you recommend that parties actively consider, using this tool to raise an objection during the proceeding?
Yes, it's a good question. I think there's no one size fits all. It very much depends on the situation itself. In some cases, of course, the jurisdictional objection basis only becomes apparent subsequently, in which case you wouldn't raise it. I think conversely, or wouldn't be able to raise it because it hasn't become apparent. Conversely, there are situations where the objection is very, very obvious, in which case you might just decide to make the objection straight away, and hopefully the court decides in your favor and the arbitration doesn't progress because the other party lets go at that stage. In other cases, tactically, you might decide, well, let me raise it before the court, and hopefully I have a decision in favor from the court. And even if the tribunal then looks at the issue again, the court's decision is, of course, of some persuasive power. So again, no one size fits all situation, but in general, I think broadly speaking, clearly, if you think you have a strong basis for making the objection, then I would make it earlier rather than later and see how that goes.
Yeah, in particular, given that the respondent normally wants to delay the proceedings, so probably they want to use this tool. I see we have one question from the audience, which is about the EA order. So I will invite Kelvin to answer this question first. If any other panelists have comments, please feel free to jump in. So the question from Pillai, Mrs. Pillai, is an EA order deemed tribunal award under the New York Convention for the purposes of enforcement? I think Kelvin touched upon this question before, but time is limited. So let us invite Kelvin to illustrate your answer to this question.
Yep, sorry. So as I've highlighted, I think one of the problems whether we call it a problem or not, is that the New York Convention has left the issue of award really to the national legislation. So I think when we're looking at the SIAC rules and considering the issue of the EA, one of the important things is to consider, well, which is the seat of arbitration and what are the laws governing those relevant jurisdictions. Well, again, given that, well, we're talking about SIAC most of the time, well, again, as a Singapore lawyer, I'll speak from a Singapore perspective. I think in terms of the rules, they've been drafted broader than I think what the law is. So it prescribes that you can either get it in the form of order or award. And really in the Singapore, I think when I dealt with a case coming to 10 years ago, that was one problem that came out because there was an interim order granted by a tribunal. It wasn't an emergency arbitrator at that point in time because I think the process hadn't really been adopted. But essentially what happened was that the other party then went to court to apply to set aside the order. Well, at that point in time, the SIAC, the International Arbitration Act in Singapore actually was quite clear about the definition of award, and that excluded an interim order. But notwithstanding that, because there was actually an application for setting aside before the court actually had to take into account well, the facts of the case and to decide whether or not to perhaps set it aside. And when you have a setting aside, well, the courts in which we were trying to seek enforcement of the interim order wasn't prepared to let it go ahead until the setting aside had been heard. So actually in PT Pukwaf-Winda, which I cited, and I was actually one of the counsel on the case, the irony was that we actually got the final award enforced before the interim order, which actually comes as a major surprise. But we had that court judgment really to clarify that an order is not an award and therefore not subject to setting aside. But in other jurisdictions, if you have some ambiguity as to that, then whether you frame it as an order or an award could potentially, create other procedural challenges like setting aside in those jurisdictions. So again, I don't think there's a one clear answer. It really boils down to the jurisdiction you are in. And it would be important based on the relevant laws of the seat of arbitration to determine whether or not at that point in time, whether there's an advantage framing it as an order or an award.
Thank you, Kevin. I do agree with your conclusion that it depends on the jurisdiction. So in many SIC cases where an EA award has been rendered, we see that some of the EA award was enforced under the New York Convention in jurisdictions like US. But I'm not quite sure, if this is a uniform solution for all. And we also have EA awards enforced in India after those awards being converted into the court order. And talking about enforcement of EA decisions and EA award, I really want to ask Vicky's views on this because obviously, Chinese law is ambiguous on this issue, and I think that the audience would be curious to know how would you advise a Chinese client when you need or when you need to respond to a EA application?
So as you mentioned, it's not tested yet in China as to whether the parties would be able to enforce an EA award according to the New York Convention. But I think what I can share is firstly, the emergency arbitration is more and more relevant to the Chinese parties because now when we are dealing with cross-border transactions or, for example, the Belt and Road, those kind of projects where the Chinese, for example, the Chinese contractors may bring finance, we bring the fund together with their project overseas, then the Chinese parties may have assets out of China. So this is when the EA order is very relevant to the Chinese parties because they will not be protected by the mainland China jurisdiction where it is difficult for the foreign parties to seek for interim relief from the Chinese court. So in this sense, I would, so So the Chinese parties, they are very interested in understanding what this kind of emergency arbitrator proceeding work. And also they are more and more active in responding to this kind of interim relief, and they have more experiences even before the courts in some common law jurisdictions, especially, for example, Singapore or Hong Kong. So I think it depends on the parties, how they wish to encounter this kind of, for example, the foreign parties trying to enforce EA order against Chinese parties overseas, but just generally, I think it is more and more relevant to the Chinese party.
Right.
Yeah, and if I can just jump in on that, Tian, I very much agree with everything that Vicky said. And just to give an illustration, there's a case we were involved in where both sides were Chinese parties, and both sides were busily fighting the EA applications. So there were two of them. There was a first EA application, and then there was a clarification in the form of a second EA application. And both Chinese parties had assets overseas, and both were fully concerned over the result of that decision. There was no question about whether you can enforce it in the PRC or not. And of course, there's a practical point that, as many of us will know, if there is an EA decision ordering a party to do something, and quite apart from enforcement, the party refuses to comply, that of course gives a very, arguably, it gives a negative impression to the tribunal. And of course, many parties want to avoid that.
Right, thank you, John. So for Hui Ming, I said at the very beginning that I do have a question for you. In our daily case management, I came across quite a number of notice of arbitration that are excessively brief, very brief. They only contain, the required information of Rule 3 of SIAC Rules. Would you agree that it is a good strategy to file a very brief notice of arbitration, because you may somehow illustrate your claim in the statement of claim, and the parties are not barred from doing this at a later stage?
Yes, actually, I would agree in putting in as brief as possible based on the SIAC rules requirements. And I mean, this is really very typical of litigation strategy generally, because we try to hold our cards to ourselves for as long as possible, right? And then for the notice of arbitration, usually, I mean, we all know that after that you have the chance to file the statement of claim, and so you can always put in everything else that you want to. And as I also mentioned earlier during my presentation, where if you put in more information in the notice of arbitration, that will also give the other party more time in preparing their response, as well as the defense, the statement of defense. I mean, I just want to bring back to what I earlier mentioned that, however, if there is a concern about limitation period, then one must be more mindful about pleading the causes of action sufficiently, because it is no longer about trying to hold your cards to yourselves for as long as possible, or taking the other side by surprise, but to actually ensure that your claim is not time barred.
Thank you, Hui Ming. I see we have another question from the audience. It's about the jurisdictional objection. What is the negative effect to raise an objection if it failed in the initial stage? Maybe John, you want to address this?
Sure. Sorry, can you repeat the question a bit again?
Yes, the question from Sun Qi Wei. What is the negative effect to raise an objection if it failed in the initial stage? As we know, challenge and award enforcement stage may bring indemnity cost.
Well, stepping back a little bit. So if there is a jurisdictional objection that one wants to make, you need to make it. You can't hold back on it. So it's not, so in that sense, the only kind of negative downside of not raising is you lose the right to make the objection. Now, of course, if you do make the objection and you fail, then there are some downsides. There are consequences that flow from that. And also, depending on the nature of the challenge, it may taint the tribunal's views of the merits of the objecting party. So for example, if a party makes quite a fundamental challenge to the jurisdiction of the tribunal, then the tribunal may form the impression, rightly or wrongly, that the party is trying to avoid an actual fight on the merits, or that they're deliberately trying to derail or delay the proceedings because, again, they don't have much of a story to tell when it comes to the actual merits or the facts of the case. On the other hand, there are certainly situations where parties will make a jurisdictional objection. It's a perfectly legitimate one. They may ultimately fail in that challenge, but because on the face of it, it's a perfectly fair challenge, then I think there is much less of a risk that the tribunal's views of the party will be tainted, and they may well appreciate this is a perfectly fine, understandable challenge. Ultimately, we don't agree with it, but it's a fine, fair challenge to bring, in which case I think some of those downsides I mentioned are lessened. But of course, again, there is clearly the risk of an adverse costs order against the party who brings the jurisdictional objection and fails.
Right. Just to follow this question, can I ask you, John? So in the SIAC rules, we can see that there are, at different time points, the parties can raise jurisdictional objection. They can raise it, as we discussed before the constitution of tribunal, and then after the constitution of tribunal, and then, as a matter of early dismissal. So how will you advise the parties to use these, to make use of these procedural tools, and to make sure that their objection succeed? Do you think kind of repeated objection would be helpful?
Usually not really. Now I've mentioned, so you touched on 3 different points: raising it before the court, raising it before the tribunal, and raising it as part of the early dismissal procedure. I've touched on the relationship between the court and the tribunal, so I'll kind of move on to the early dismissal point, which is an interesting one. So the early dismissal objection is where you're saying that a claim or defense is manifestly outside the jurisdiction of the tribunal. And of course, the nature of the early dismissal process is that you don't really then have the benefit, obviously, of going on to the court challenge if you fail. Whereas if you do make the challenge under Article 28 of the rules, under the normal jurisdictional challenge objection procedure, then, as I mentioned, you then have the opportunity to have a second bite of the cherry. Again, no one size fits all. I've laid out some of the pros and cons, but in quite a number of cases, I think it's fair to say that parties will consider raising it under Article 28 as a jurisdictional objection, rather than, as it were, relying on Article 29, which is, as I said, where you need to show the claim of defense is manifestly without or outside the jurisdiction of the tribunal. In addition, you don't quite have the benefits of the court challenge that you have under Article 28.
Thanks, John, for the clarification. I see that our time is running. And so we will reserve 2 questions before we finish the session. One question I would raise this to Vicky. So I heard about this in our real case management. Some parties, when they have kind of multiple contract, and in my opinion, they are obviously compatible, and they can apply for consolidation, but they didn't. So the council told me that because the award would be enforced in China, so they worry that China is a jurisdiction that is hostile to those procedural tools such as consolidation. Can you please clarify and let the audience know if this perception is right or wrong?
That sounds with some kind of bias against the Chinese court, which I don't agree, of course. I think it's not a general hostile against consolidation in China. So it's really depends on what's the circumstances in the case. What I can say is maybe the Chinese court, they are more cautious or very careful about all these procedural matters, especially whether the procedure have been inconsistent with the parties' agreement, especially those agreements that are clearly indicated in the parties' arbitration agreement. So I think just as a general question, I don't think there is any hostile against consolidation. But of course, regarding consolidation, I think the general pros that people talk about consolidation is usually, firstly, it's maybe more efficient because you consolidate several arbitrations together. But I think efficiency is to which party, that is something the different parties may have different thoughts, because, for example, the general contractor would like to bring the subcontractors into an arbitration, which the principal commenced against the general contractor. Then I guess the principal will not be happy to consolidate an arbitration which includes all the subcontractors. So that is the efficiency issue, which I think is depend on the parties. And secondly, when we talk about consolidation and joinder, we also talking about this may diminish the potentially conflicting decisions made by different arbitral tribunals. So that also brings the question as to, for example, if I am the respondent in arbitration A and I am the claimant in arbitration B, then I may make different submissions in these two arbitrations. However, if you bring the two arbitrations together, it makes me must have the same positions or make all the same views to the same tribunal. So I think those would be the questions that the parties or the councils would think about before they decide whether they would like to consolidate or join the additional party into the arbitration proceedings.
Right,
Yeah.
they do need to have a very good strategy with the help of lawyer. John, I see you have some comments to add.
Yeah, I just want to very quickly add a practical example. Recent case we had, it was a consolidation of both contracts and parties, obviously a foreign arbitration, and it was then brought to enforcement in the PRC. The other side objected, amongst others, on the basis there was a wrong consolidation. There was a complicated question around joint and several liability to costs and how you split that in the context of consolidated respondents. But in short, the PRC courts dismissed those arguments. We got the award recognized. I'm happy to report. And they did not, they were not waylaid in any way by the arguments around forced consolidation.
All right, thank you so much, John. Thank you, everyone. I see that our time is up, so we need to wrap it up. Thanks for joining us. Please let us know if you have any other questions. You can send us email or can reach out to our speakers today. Okay, so we will wrap it here, and we hope everyone a very good weekend. Take care. Bye-bye.
Bye.
Thank you. Bye-bye.
Thank you.